Dear ladies and gentlemen, a decade has passed without the legend. However, you would agree with me, the legendary work and the masterpieces continue to add value to all of us. A very warm welcome to all of you for the 4th Biennial Professor Uditha Liyanage Memorial Oration. And to start with, let's rise to the national anthem. May I now call upon and invite Dr. Asanga Ralasinghe, Director PIM, to address you formally and welcome you.
Very good evening, Aibowan. Welcome to Postgraduate Institute of Management of the University of Sri Jayawardenepura. Dr. Harsha Kapral, our orator for this evening's event, Board of Management member, and all other Board of Management members of PIM, Board of Study members of PIM, faculty members, University of Sri Jayawardenepura faculty members, Mrs. Liyanage, Miss Liyanage, ladies and gentlemen. So first and foremost, we are deeply honored as PIM to conduct this event for the 4th time in this venue, at a time when PIM has started a new journey in terms of trying to be the business school or adapting to be the business school for the new world. In this direction, if Professor Liyanage had been there, he'd be very happy with what we have achieved in terms of getting accreditation to be Sri Lanka's only business school to be accredited among South Asia's top-ranked business schools. And we are striving to take this forward in terms of getting global recognition, which Professor Liyanage and the directors before me had laid the foundation. So Dr. Cabral, you're very aware with what we are planning to do and what we've done at PIM as part of the PIM Board of Management. At a time when marketing is evolving in this new world, where the role of a marketer is also evolving, the foundations of Professor Liyanage's work is still very relevant. Recently with Dr. Ravi Bamanusinghe and 2 others, Mrs. Bamanusinghe and Ash, we went back to the work Professor Liyanage has done, and we improved on his work and published a new book on the contemporary Sri Lankan consumer based on the great work he has done. When in most organizations, when boardroom discussions are limited to looking back at financial performance or audit issues, looking back at lagging indicators, Professor Liyanage, sitting in many boards, was trying to get the leadership of Sri Lankan organizations to look at the future by focusing on the marketplace and how to win in the marketplace by creating and keeping customers profitably. Long time ago, Professor Liyanage invited me when I was working at Unilever to come and share the sunlight story. And that is how I started my PIM teaching journey. And I'm so grateful for that decision he took to bring people like me from the industry to come and lecture at PIM. Like me, there were so many who came, and Professor Liyanage made sure that we are very comfortable at PIM and then are valued at PIM. So today, we still think about the great work he has done. Especially when we wrote this book, we were reading the last edition of Professor Liyanage's Profiling the Sri Lankan Consumer, and we found that the amount of detail, the attention to detail he had gone into in writing that book, it became very difficult for us to raise the bar from very high standards he's already achieved. So today is going to be another memorable day. I've listened to Dr. Cabral. I have had the privilege of sitting with him in private sector boards, and these days he's with us in the PIM board. The discussion we have in the board meetings, the rigor that he brings into the discussions is just amazing. So, ladies and gentlemen, it's wonderful to have all of you here. I hope this evening is going to be a memorable evening listening to Dr. Harsha Kabra. All the best, and let's have a great evening.
There were 4 sets of criteria: brand intent, brand content, brand process, and brand performance. Now, I would like you to note this point. The first 3 that I mentioned relate to what you did. If you like, the drivers, the enablers. And the 4th one, brand performance, is about the results that you've achieved, the outcomes that you've achieved.
Now, what is a case study? I would like to define a case study as a good story that is well constructed and well told. A good story, well made, well constructed, and well told. And this is my simple definition of a good case study. A good story is underpinned by a intriguing plot. So when you write a case study, you must have a plot that's compelling, that's intriguing, that's interesting.
I coined a phrase in order to make this fundamental distinction. And that is what I call the difference between bolt-on nation branding versus built-in nation branding. So if you are really thinking about this much debated subject of nation branding, then we must look at not bolt-on, not tagging on a brand image, but a built-in nation branding strategy, which I will attempt to describe briefly over the next few minutes.
A man who can carry the burden of others on his shoulders and yet tread lightly is possibly one of the rarest things in this world. Someone who carries himself with decorum, treats others better than he expects them to treat him, and prepared to commit himself to hard work with dedication and integrity in ways that are exemplary is inimitable. Professor Uditha Liyanage stood out as a visionary, a leader, and a guiding light in times of need, synergizing the fields of marketing and management and reaching the highest echelons as a professor of these disciplines and as a teacher of great life lessons. During his invaluable journey, his enormous contribution towards the marketing fraternity by being an integral part of the national body for marketing, SLIM, is unprecedented. He was the local genius to sit next to the global marketing guru, Philip Kotler, and reveal his own theories and viewpoint when SLIM facilitated Philip Kotler in Sri Lanka. He was the brain behind the concept Mod Tradi Consumer, thus identifying a hybrid consumer living among the Sri Lankans. Above all, he was the advisor to the committee and panel of judges of SLIM Brand Excellence since 2007. He crafted and improved. It is with heavy hearts that we wish Professor Uditha Liyanage a final farewell at this ceremony. We also wish good fortune to his family and friends in his absence. Thank you, Professor Uditha Liyanage, for showing us the way. You will remain a guiding light to all those who encountered you and etched you within their hearts.
Let me congratulate the winners tonight. You've done well to be here tonight. Let me also congratulate the non-winners who are here tonight, because you've done the only thing that matters in life, to embark on that vital, pivotal journey of going from good to great.
To introduce our orator today, may I have the privilege of inviting another eminent personality in Sri Lanka, someone who has contributed both to management and marketing in corporate entities, and someone who has contributed society in large with valuable messages, and someone who had been close to late Professor Uditha Liyanage. I am honored to invite Mr. Deepal Suryarachi on stage to introduce our orator.
A very good evening to every one of you. Dr. Harsha Kapral, Director PIM, members of the Board of Management of PIM, Uditha Liyanage, Oration committee members, members of the family, Shreyani and Chaturi, and those who are friends of Uditha, and ladies and gentlemen. It is indeed a distinct honor to introduce our keynote speaker today, a true titan in the fields of law and commerce. Some people build careers, but our speaker today has helped build the very legal framework of this country. He, in many ways, resembles certain qualities that we admire in Uditha. Uditha was an academic who brought that academic knowledge into corporate and mentored many. Dr. Harsha Cabral has done all that the same way. And both Uditha and Harsha have something very unique, that they are very fine human beings. I think for me, that's the best fit. As a legal luminary, for over 30 years, he has been a pillar of the legal profession in Sri Lanka. As a President's Counsel, Dr. Harsha Cabral commands an extensive practice in the commercial high courts and Supreme Court, specializing in areas like company law, intellectual property law, commercial arbitration, etc. His expertise isn't just theoretical. He holds a doctorate in corporate law from the University of Canberra, Australia, and his work has had profound impact across the world. I would also like to call him an architect of change for the single reason that Dr. Cabral was a key contributor to the Advisory Commission on Company Law, and he was one of the masterminds behind the Companies Act number 7, 2007, which just saw some amendments to it, the very law that governs the corporate sector today. His influence extends globally. He served for 6 years on the prestigious International Chamber of Commerce's Court of Arbitration in Paris and assisted the World Bank in drafting Sri Lanka's latest insolvency laws. He even traveled to Maldives on behalf of the Sri Lankan government to educate their legal community on commercial arbitration. And his contributions beyond the courtroom, his influence isn't limited to the courtroom. He has held numerous high-profile leadership roles. Currently, he serves as the chairman of the National Savings Bank, NSB, and the Tokyo Cement Group. He has also served as a director of some of Sri Lanka's most prominent business establishments, including Haley's, Sri Lankan Airlines, and Chevron, demonstrating his practical application of legal and business principles. And of course, he serves on the board of PIM as well. His lifetime mentorship has taken many shapes. Beyond his active practice, Dr. Cabral is a senior visiting lecturer at several universities here and abroad. Even at PIM, he imparts his knowledge generously. He is a regular speaker at public seminars and the author of several books on corporate law, sharing his wealth of knowledge with the next generation of legal and business professionals. Please join me in extending a very warm welcome to a man whose dedication has shaped laws, mentored leaders, and continues to drive the nation forward. May I invite Dr. Asanga Singh to bring the honorable guest here to deliver the keynote speech.
you, Dipal, for those nice words. Good evening to everyone. I'm indeed deeply honored to deliver the Professor Uditha Liyanage Memorial Oration today, and I thank the committee inviting me to do so. Uditha's dear wife and my friend Sriyani, their versatile daughter Chaturi, close family members of Uditha, sister Deepani, and brother-in-law, my dear old friend Rohit Dias, Uditha's younger brother Dhammika. The organizing committee consists of Dehan, who has done a wonderful job, I must say, a very, very meticulous organizing chairperson, Erdly and others, including Deepal, the director of PIM, my friend Asanga, distinguished members of the PIM, my fellow colleagues at PIM, distinguished invitees, including my dear friends Ranjit and Jeevani Panditake, Mr. Lalit Veeratunga and Indrani Sumitadasa, several of my other colleagues, ladies and gentlemen. Late Professor Uditha Liyanage, who lived in this world for a short span of 61 years and who left us 10 years ago, was indeed a legend and a colossus in the academia, especially in the field of marketing. A man who rose to the top as a marketing executive, who later switched gears and became a prosperous academic, ending up as the best marketing guru in Sri Lanka and a national asset in the field of marketing and management. In fact, Uditha is the one who first invited me for a guest lecture at PIM long years ago. I first got to know Uditha in the late 70s when he was still in the private sector as a top-notch marketing man. Rohit, who was working with me at CIC in the late 70s, was at that time courting Uditha's sister Deepani. And I can remember Rohit obtaining short leave at 3 o'clock to go and meet Deepani at the Green Cabin those days. I don't think Uditha knew about it. Rohit brought in Uditha's younger brother Dhammika as an intern to CIC too. Later in 1984, when I was doing an executive diploma in business administration at the University of Colombo, where I had to do a presentation on the toothpaste market in Sri Lanka for a marketing assignment. Through Rohit, I met Uditha at Shaw Wallace and Hedges in Kolpiti, and he advised me how exactly I should do it. Our marketing lecturer happened to be the late Stanley Jayawardena of Levers, and Uditha helped me how to impress him, and I managed to top that batch that year. Years later, in 2006, Uditha and I joined the board of Demo PLC, independent directors, on the invitation of Ranjit Panditake. Uditha, for his marketing expertise, may be law for me. From 2007 to 2015, I had the good fortune of associating this great man who was for me larger than Kotler in the field of marketing and management. He had his own delicate style of reducing any big issue to an A4 sheet with a little chart. I think Ranjit knows it very well. He and I worked together on the judges panel of the annual Chairman's Awards at Haley's Group for several years, and he chaired the panel until his demise in 2015, and I took over from him and continue same to date. Uditha's contribution to the academia and especially to PIM is unmeasurable. This is a fact known to me very well as I was involved with him closely along with Dr. Vikrama Veerasurya. Uditha was a rare gem, a valuable academic, and a true gentleman hailing from an exceptionally decent family which followed the true Buddhist principles to the letter. Now I come to the theme of the presentation or the subject matter of the presentation. Before that, I must tell you, this is the first time I'm reading a written speech. I never do that for lectures, or I don't do, as I said, I've never done PowerPoint, I don't do PowerPoint. Maybe we are not paid for that in quotes. We have to speak. And for two reasons, I had to do a written speech, have a written script. Jan said that they will publish at some whatever point. And number two is, I had to be very accurate in what I say today, because my regulator is also seated here, my wife, Lucky. Because I have the freedom not to have, when I do my lectures, where I can do a little bit of unorthodox shots too, but today I have to be very careful in what I say. This presentation begins with an overview of corporate management inter alia by identifying at the outset who a director is in the Sri Lankan perspective. Thereafter, I would discuss the relationship between a director of a company and the articles of association therein. In doing so, I would deal with the different types of labels hooked onto directors in practice, a distinction not to be found within the provisions of the Companies Act No. 7 of 2007. Thereafter, the second part of my presentation dives into a discussion of the various responsibilities of directors, identified with both within the Act and in other statutes. I also deal with the corporate liability and personal liability of directors, touching upon corporate and personal guarantees. Next of my presentation, I try to discuss the protection afforded to directors. This part deals with, inter alia, the statutory framework of protection afforded to directors and otherwise. Finally, I also set out several golden tips sitting and aspiring directors, which they have to follow. This is something which will be helpful to everyone. Let's start with corporate management, the company and its management. I quote Bruce Welling from Canadian corporate law. Every corporation must have a board of directors. Most also have officers. The position of directors tends to be defined or at least commented on in every corporation statute, whereas the statutory coverage of officers tend to be somewhat haphazard. Understanding the roles and obligations of both is key to understanding how corporations actually work. Unquote. The directors of a company have control of the day-to-day management functions of the company, with which the members or shareholders cannot interfere. This is a basic company law principle established more than 100 years ago in the House of Lords in England. The shareholders cannot usurp the powers granted by the Articles of Association to the directors, and similarly, the directors cannot usurp the powers granted by the Articles of Association to the general body of shareholders. The directors and the directors alone are responsible for the management of the company, with the exception of matters specifically allocated to the company in general meeting or the shareholders or members meeting, which is commonly known as EGM or AGM. Several jurisdictions which have followed modern corporate law mechanisms have built into their corporate statutes this common law principle that the powers of management of the company are vested in the board of directors. Sri Lanka too, following New Zealand and several other developed jurisdictions such as Canada, has given statutory effect to the same. In fact, the 1860 Joint Stock Companies Act, 1938 Companies Ordinance, 1982 Companies Act, none of this had this. So we specifically put it in black and white that companies are managed by a board of directors appointed by the shareholders. That's a common principle, very strong principle. If shareholders were to run companies, billions of shareholders will be running John Keats. So you have a limited number of places for a company shall have at least one director, except a public company which should have at least two directors. Listed companies should have a minimum of 5 directors under the current listing rules. The Articles of Association, in its discretion, can spell out the minimum number of directors and the maximum number of directors the company must have and the quorum for its meetings. The Articles of Association of the company shall govern the proceedings of the board of a company, the board meetings. Now, these board meetings are different to the shareholders' meetings, and shareholders are not privy to board minutes. So that is something the board board members should know their responsibility. The shareholders don't know what goes on inside the boardroom. The management function of the company in Sri Lanka is set out very clinically in Section 184. This provision of the Act says it all. It's a basic principle in company law that members or shareholders of companies do not run companies but appoint a board of directors to manage a company. Shareholders too, if they so wish and if they can muster adequate support at the shareholders meeting, can get themselves appointed to the board to manage the company. The Companies Act also permits some functions of the board to be delegated and some not to be delegated, as a particular section of the Act with the schedule spells out the details. In some companies, in some jurisdictions, the directors are all non-executive. In most of the banks, you have only one executive director sometimes running the place. And there are certain American companies, they have a paid CEO, paid CFO, paid COO, who do all the work and they are told what exactly to do. And if they don't perform their duties on contract, they're kicked out. You can see Apple or Ford or whatever organization where this happens. Now let's see who a director is. Who is a director? It is important to note that if the definition fits the individual, then he or she becomes a director under the law, maybe with whatever name tag: executive director, non-executive director, independent director, nominee director, alternate director, shadow director, chairman, president, etc. Because the section defining the director under section 529 is a long definition. It goes on for pages who a director is. So there are some situations where you find directors are not seen on paper. They are puppeteering. They have country managers running the show. Even that manager can be hauled up as a director if the cap fits him. So the nomenclature doesn't matter. In addition to being a director appointed by the shareholders, the same individual can be contracted by the company for employment. Example, as the managing director or a chief executive officer. In such a situation, he will be a director on the board appointed by the shareholders and also an employee or an executive by contract with the company. Then he will be wearing two hats at the same time, as the director of the board and also an employee executive of the company. Advisors to the board and not to the company providing professional services for a fee or otherwise cannot be treated as directors. That is specifically said so. However, they must ensure that their actions do not fall to the director category as specified therein. The Companies Act refers to only directors, but the articles may refer to managing director, executive director, non-executive director, and corporate governance regime will refer to independent director. Nowhere in the 534 sections you will find the word executive director, working director, all that is in your articles. But then the corporate governance brings in another regime for independent directors. I quote a case from an Australian case from 1992, AWA versus Biennial. Of necessity, as the complexities of commercial law have intensified, the community has come to expect more than formally from directors whose task is to indeed govern the affairs of companies to which large sums of money is committed by the way of equity, capital or loan. The affairs of the company with a large annual turnover, large stake in the assets and liabilities, the use of very substantial resources and hundreds if not thousands employees demand an appreciable degree of diligent application by its directors if they are to attempt to do their duty. To some extent, this has been recognized by the fact that the compensation paid to non-executive directors has changed from a modest honorarium to a sum which bears a measurable relationship to the work expected of the director. Indeed, it has led to a number of professional non-executive directors on boards. One of the most striking features of the law concerning directors' duties is the insistence that directors accept more and more responsibility for the oversight of the company's affairs at the same time as the affairs of the companies become more and more complex and diverse. Unquote. The director's duties are catalogued in a statutory form for the first time in Sri Lanka in the Companies Act number 7 of 2007. When the task was given to us to draw up this new act, there were 10 position papers, and one happened to be the responsibilities and the role and the duties of directors. This is a revolutionary step forward in the corporate arena. Hitherto, the duties of directors had to be ascertained from the common law, case law on the issue. If the directors are to be held responsible for their acts, there should be a clear identification of their responsibilities and duties. The provisions of the Act provides it now. To have a director's chart of duties and responsibilities, and also to provide the directors to rely on information and advice on experts to enable them to act in good faith are features of modern corporate law. The provisions relating to directors also provide for indemnity and insurance in given circumstances as set out therein. It is pertinent to note that the provisions in the Act provide a clear set of guidelines to directors in particular and to the commercial world at large. There was much debate on this inclusion, and the provisions were finally adapted to the Act as they complement the other new provisions in the Act as well. Thus, the provisions of the Act provide a basic code of ethics for the board. This has come essential as qualifications to become a director is not very rigid. To become a company secretary, you have to be a qualified person. You have to be a chartered secretary or an accountant, chartered accountant, or an attorney at law. To be a director, you don't need any qualification. Just like doing politics and becoming an MP or becoming a minister. The fate of the company depends largely on its performance of the board. If the shareholders appoint competent directors to the board, then eventually the competence of the directors will be reflected on the performance of the company. On the contrary, if the shareholders appoint idiotic directors to the board, the repercussions will be the same on the performance of the company vis-a-vis unwise management. I quote Templeman J. in Daniels versus Daniels, 1978 case, a Chancery Division case. The idea that the shareholders were ultimately responsible for the unwise appointments of directors led to the duty of care, skill, and diligence which a director owed to a company being characterized as remarkably low. However ridiculous or absurd the conduct of directors, it was the company's misfortune that such unwise directors were chosen. To put up with foolish directors is one thing. To put up with directors who are so foolish that they make a profit of £115,000 odd at the expense of the company is something entirely different. Unquote. It is essential that the board of directors ought to be aware of the civil and criminal liabilities under the Companies Act. There are in fact 133 provisions in the Act which attracts civil liability and 31 provisions attracting criminal liability. Most of them are not tested yet. Now the time is coming where these are to be tested. They must also be aware of the other relevant statutes when the company is listed. There may be other statutes too that will impact on the conduct of the directors depending on the functions of the company. Example, banking. However, the directors can rely on the mechanism of protection referred to in the Act and also rely on protection from courts in given circumstances. Now I come to the directors and the articles. Articles of Association is the document which provides the internal management mechanism of the company. In New Zealand, this is referred to as the constitution of the company. This in fact contains a contract between the company and each shareholder and between the company and each director and company secretary and between each other shareholder of the company, under which each party agrees to observe and perform the functions set out in the articles. Now, I must say that as a lawyer, when corporate issues come up, when directors come to see us for advice, first thing I ask is, have you brought your articles of association? They know that there is a document like that, but they have not looked at it. That is very important because that is your constitution. In the country, you have a constitution. Company, that's the articles. The articles will set out most of the details which are not in the Companies Act. The doctrine of ultra vires acting within its powers in company law is not available under the present Act. However, under the provisions of the Companies Act, the company can adopt a statement of objects if it so wishes in the Articles of Association. An act of such company is not, however, invalid merely because the said act is contrary to or beyond the said objects in the articles. Because prior to 2007, the objects clause was a very important thing. If the company's objects were restricted, say importing vehicles, you can't do anything else. You have to go to court. It was very not easy to get. Now you can do anything. You import vehicles, and if you can't sell the vehicles, you can hire the vehicles. You couldn't do that under the old law. So flexibility had come in. An act of such company is not, however, invalid because the said act is contrary to or beyond the objects and the articles. The directors, however, can be liable for acting in breach of the provisions of those if there is an objects clause in the Articles of Association. The director of a company shall not act or agree to the company acting in a manner that contravenes any provisions of the Companies Act or the provisions contained in the Articles of Association of the company. So a brief understanding of the Articles of Association, at least to read it once if you're on a board, is advisable. Then I come to independent non-executive directors, which are most of the listed companies. Executive and non-executive directors on boards of companies have been the norm in company law for several years. Executive directors are full-time employees of the company with specific functions assigned to them by the company with properly defined contracts. Non-executive directors, on the other hand, do not carry out executive functions for the company, but serve on the board as non-executive directors. The Cadbury report in 1992, which brought in corporate governance to the world, before that no one talked about corporate governance, highlighted the importance of non-executive director bringing into the board independent judgment. Pursuant thereto, the corporate governance mechanisms have encouraged the introduction of independent non-executive directors on the boards of listed companies. I quote Robert Tricker on international corporate governance. In the last several decades, there has been a dramatic shift away from boards dominated by inside directors towards boards dominated by outside directors. A principal reason for this change has been the growing concern that inside directors, i.e. the corporate employees, tend to be self-serving. Unquote. The latest mandatory rules on corporate governance in Sri Lanka for listed companies indicate that the board of directors of a listed company shall include 1/3 of the total number of directors to be independent. The minimum number of directors on a listed company is 5. 2 or 1/3 of non-executive directors appointed to the board of directors, whichever is higher, shall be independent. Further, the board shall require each non-executive director to submit a signed and dated declaration annually, his or her independence or non-independence against the specified criteria. Board subcommittees as defined can be chaired only by independent directors. The said mandatory code inter alia deals with non-executive directors, independent directors, disclosures relating to directors, and criteria for defining independence in detail. Whether the novel corporate governance concept of having a fair number of persons on the board as independent non-executive directors is productive or counterproductive to the growth of the company is not really tested in Sri Lanka yet. Several international jurists, however, are of the view that the role and effectiveness of independent non-executive directors has been overemphasized in recent times. Since the independent non-executive director is also treated the same way as all the other directors on the board vis-a-vis duties, responsibilities and liabilities, maybe at times such an independent non-executive director will be overcautious in decision making, which can be a detriment to the growth of the company. However, it is an accepted norm today that independent non-executive directors bring into the boardroom a wealth of experience and a wide range of expertise and skills on the particular issues to strengthen the management functions of the company. When in fact, independent non-executive directors are appointed to boards, the set criteria should be considered seriously. Apart from the valuable expertise they carry with them on board, They ought to ensure that their independent viewpoint is focal on management decision making. The independent non-executive directors must also be aware that they are also kept as gatekeepers or watchdogs of the company to check on self-interest and other abuses within the corporate management. They must be bold enough to voice their dissent when needed with gusto. Because the idea of the independent director is not just to be a rubber stamp. Because they carry the same responsibilities. They can't say, I go in only for board meetings. I don't know what is happening. Because they are privy to all the documentation. They can call for anything. So they are more than a shareholder. So that is why the whole role of independent, especially for the listed companies, the independent directors have to hold responsibility in guiding the company in the correct way. So now I come to the responsibilities per se of directors, the basic duties of directors. The duty of directors to act in good faith and in the interests of the company is set out with clarity in the current law. What the director believes to be in the interest of the company is a subject to further qualifications such as the standard of care and bona fides. Even a nominee director of a subsidiary company ought to act in the best interest of that subsidiary company and not in the best interest of the parent company which nominated him. However, if the articles of that subsidiary company permit, the director can act otherwise. A director should know what good faith or bona fide means as against bad faith and mala fides. And also he should know well that the interest of the company means the best interest of the company and none other. Thus, the duty of directors to act in good faith and in the interest of the company is the primary golden rule to be observed by every director. That's the cardinal rule every director should know. The directors are bound to comply with the provisions of the Companies Act and the articles of association of the company. This is a simple golden rule for directors across the board, all and sundry. So if you appoint a director who can't read or write, you can't expect the man to look at those documents either. You know what happened long years ago? The working directors were appointed in the government bodies. They were given WD post and a car and an office. They didn't know what to do. So that is the idea of appointing the correct director. Thirdly, a director of a company shall not act in a manner which is reckless or grossly negligent and shall exercise the degree of skill and care that may be reasonably expected of a person of his knowledge and experience. For example, an attorney at law on a board cannot be heard to say that he did not know the law, or an accountant on a board cannot be heard to say that he didn't understand accounts. This again is a simple rule to be followed by all directors. This provision says it all about the care aspect of a director on the company. This is simply similar to the parental care of a father towards his family. This again is a simple rule to be followed by all directors. Now, those three very simple rules are cardinal rules we didn't see prior to 2007. Now it is in black and white. Those days we had to look at case law, especially the English case law, to see what is fiduciary duty, what acting in good faith, what is bona fides of a director. There was the famous case of Clapham Bus Company, who were common man is, and so on and so forth. Now I come to another important one, the solvency test. The solvency test, which is brought in the new act, set out in section 57 of the Companies Act, is the golden thread that runs through the entire fabric of the act on capital maintenance of the company. The solvency test ensures that the company at any given moment is financially healthy or not, and if not, what steps ought to be taken by the company and the responsibility cast on the board of directors. That does not mean that you need to close shop immediately, but to tighten your belts and be cautious in your expenses. The example I always give is like, if you have 1,000 rupees in your pocket and if you want to have lunch, you will not walk into Hilton for lunch. But that doesn't mean you can still walk to Rahimas or Buhari or someplace and have a good meal. But you should know with 1,000 rupees what to do. I mean, if you have only 500 rupees, still you can get a nice bath packet for less than that. And so that is what it is very important. This was not there earlier in the company law. We brought in for a particular purpose. So solvency test, not just close shop and run away. This is a serious responsibility cast on the board of directors, as the shareholders might not know until later. It is simply like the warning light which blinks on the dashboard of your car, showing that the fuel level is very low. If we ignore the warning, we know what happens next. This is to the chauffeur and not to the passengers of the car who may not know about it. Only the driver gets it. So the shareholders don't know whether the company is solvent or not. So it is, if the driver is the board, and if they don't get that signal correctly, you're in trouble. In the same way, solvency test is indicated to the board of directors and not necessarily to the shareholders. The board will be held responsible for reckless behavior if they simply ignore it. The company must not have a 5-star life with a 3-star income. Duty of directors on insolvency and the duty of directors on serious loss of capital are detailed out in the Act, which the penal provisions attached thereto in particular. My friends Manil and all the accountants here, the chartered accountants and the accountancy profession knows, they know how exactly the importance of section 219 and 220 provide additional stringent responsibilities, civil and criminal, both on the director to be awake all the time. The shareholders and the creditors may not know the actual financial situation of the company at any given moment. Therefore, it is the duty of the board to arrest such drastic situations of financial crisis and act forthwith. These are two provisions of the Act the directors should take serious note of. When the going is bad for the company and the directors simply ignore and carry on as everything is perfectly normal, they are liable for the serious consequences set out in the said provisions. Unfortunately, it was rather late in the day when they introduced this. The finance company started collapsing from 70s, starting from HPT onwards, the banks, the Pramuka, and so many other. If these sections were there, the red flag should have come up much earlier. Transactions in which the director is interested, disclosure of director's interests in shares are set out clinically under the provisions. The said provisions ex facie set out the standard every director should take when it comes to conflict of interest in contracts and conflict of interest in shares. This is the minimal threshold and provides how best a director should act in such circumstances. There are 10 sections starting from 191 to 200, which deals with conflict of interest in shares and conflict of interest in contracts. That's across the board for all the companies, not only listed companies. So if there is if I'm in this company buying shares of a company where my wife is a director, there is a conflict. Because I'm privy to price sensitive information of both companies, and that should be avoided. All that is there statutorily. It is stringent when the company is listed. I'll give you an example. Now, say, if I'm on the, I'm chairing the Tokyo Cement Board, and they want to buy this, the cement mixers, those lorries with cement mixers, and they will call for offers from, United Motors, will have Mitsubishi, Nimo will have Tata, Aisha, Lanka Leyland, and a whole lot of things. So when this comes onto the board, only when that time I would see it. So immediately I have to record. Mr. Asita Talvat and myself both are on the demo board. So we shall not participate in that particular decision. Long years ago, people used to get up and go. Now it doesn't happen. But then others can take the decision. Maybe for good reason, bad reason, whatever reason, they will decide. But if I don't do that, if it is not minuted properly, at least at the next meeting, when the meeting's minutes are confirmed, I have to see that it is done. Otherwise, a shareholder or a creditor can take me to the cleaners. And I have given added advantage to a particular player. So, it is very important that they take, when the going is bad, they must make that, serious responsibility cast on the board of directors, and shareholders might not know until later. Because the shareholders may not know any of these things. Shareholders get to know much later when the annual report or quarterly reports or whatever comes up. It is up to the board to decide. The principle that the directors must not place themselves in a position where their duty towards the company and their personal interest conflict is again related to directors' good faith, best interest of the company, and the standard of care referred to above. These areas commonly fall under the categories under conflict of interest in contracts and conflict of interest in share transactions and their own gain on the same. The law expressly states that the provisions contained in the Companies Act are in addition to and not in derogation of any provisions contained in any other written law relating to the duty or liability of directors or officers of a company. Then I deal with corporate liability versus personal liability. A lot of directors want to know this issue. What are the corporate liability issues and what are the personal liability issues? The company can be held liable, civil and criminal both, under certain provisions of the Companies Act. Example, a minority shareholder can sue the company under a particular section 224 for mismanagement or for oppression and mismanagement and obtain orders against the company. Civil actions against the company under the provisions of the Companies Act have to be instituted in the High Court of the Western Province, exercising civil jurisdiction commonly referred to as the Commercial High Court. In addition to civil liabilities, there are several provisions in the Companies Act which attract criminal liability on the company and directors. All these fall under the category of corporate liability. However, there are specific provisions in the Companies Act which attract personal liability of the directors, officers as set out therein, which includes civil liability and criminal liability separately. Thus, personal liability, civil and criminal both, of directors, officers as against corporate liability is an important matter. All directors and officers should be aware of and be conscious of vis-a-vis in all actions taken by them in the company. Corporate behavior is thus under these specific control mechanisms. The threshold becomes higher when the organization is a bank which is governed under the Banking Act. There are two specific departments in the central bank that deals with bank supervision and non-bank supervision. There are a lot of bankers here. You know exactly how stringent they are. There again, I must say, happen after the horse has bolted. The said provisions are very detailed and meticulous, and every director of a bank or financial institution ought to read them carefully and understand every bit of it for proper compliance. There are certain statutes which may add several other liability if that particular organization is governed under that statute too. Example, finance companies, leasing companies, etc. The board of directors of each company ought to know and understand their respective roles and liabilities vis-a-vis that particular company is attracting. However, all companies that come under the purview of the Companies Act are bound by the provisions, civil and criminal both, referred to above. All listed companies are bound further under the provisions of the Securities and Exchange Commission Act and the rules of the Colombo Stock Exchange. So you have the Companies Act on one side, then you have the security regime, which is the SCC, CSC. We have the SCC chairperson is here. This is Sugatasan. Where another regulator comes in. And then under the SCC, you have the SCC Act and the rules, and then you have the CSC and the rules, and the CDS and the rules. That attracts the companies which are listed. There are certain other regulations too, especially for insurance business. You have insurance regulator. And telecommunication business, you have the TRC. So those are additional regulations which may come. If you are in one of those companies, you ought to know those as well. Then I come to another important area for employees use, corporate guarantees versus personal guarantees. This is another big issue for big corporates. Where should I give personal guarantees? Because when you're giving a personal guarantee, keep in mind you're giving your neck. If it is a fact that lending institutions, including banks, obtain collateral for funding the company. In most instances, corporate guarantees or collateral from the company is adequate. However, in certain cases, in addition to corporate guarantees, the lending institution requests for personal guarantees of directors which can be strong and easily enforceable. You take the chairman's car, you don't have to go to courts to recover 150 million straight away. That is enough. This function is by voluntary contract, and if a director has given a personal guarantee, he is bound by the terms of that contract, which you may not read when you're signing. When the company is in default, this is a serious situation wherein the lending institution can easily go against the director's personal wealth as per the contract. Thus, any director providing personal guarantees for corporate gain must consider the consequences of the default. It may be normal if the director holds a large stake in the company or a similar situation where the only collateral that can be offered to the lending institution is his personal property, as the company has none. In most of the personal guarantee contracts, it is common to see that the director providing same gives an undertaking that any property in his name on that date, mentioned or otherwise, shall not be alienated thereafter without the express permission of the lender. The bankers know this well. Thus, once it is pledged, the director is prevented from selling or alienating the same or part of it without the permission of the lender. Directors providing personal guarantees for the benefit of the company ought to take note of the consequences thereof. Independent non-executive directors should not provide personal guarantees on behalf of the company to lending institutions, and all other directors should act with care and diligence when they give personal guarantees on behalf of the company to lending institutions. Then I refer to a couple of other statutes. EPF, ETF, gratuity liabilities, and other statutes that can attract liability on directors. This has become a very, very common feature now in the corporate world. The personal liability of directors for non-payment of EPF, ETF, and gratuity has been in the statute books for a considerable period of time. In Sri Lanka, this has been a perennial complaint by the corporates as they hate to be called upon in the magistrates' court on criminal charges. These are, however, safeguards guaranteed to the employees of the companies, and the directors at all times must ensure that all the said statutory payments are made on time by the company. Besides, there are further liability on the directors based on several other newer statutes such as the Consumer Protection Act, Anti-Corruption Act, Anti-Money Laundering Act, Data Protection Act, Computer Crimes Act, Electronic Transactions Act, etc. Large number of these statutes have come up during the last 10 years. A fair understanding on the specific liabilities is important for the directors as an abundance of caution. If I can give you hundreds of cases where the top corporates are awfully scared of this. They are hauled up in the magistrate courts, and this is not a place you would like to go and sit. That is one of the dirtiest places. I would never want any of my colleagues to go there. Then I touch on the government nominee directors. The Secretary to the Treasury's ownership in shares in companies and the special role played by such holding is expressly recognized in the Companies Act of 2007. This is to ensure that the state ownership of shares is adequately protected. The government nominee directors, where such directors are nominee directors of the state, are vis-a-vis nominees of the Secretary to the Treasury. They can be nominated and be removed by the Secretary to the Treasury alone and none other. However, the government nominee directors must be aware that there is no immunity from liability by being government nominees on the board. Under Section 4 of the Act, the Secretary to the Treasury is also permitted to incorporate a single shareholder company. Under the provisions of the Companies Act regard to attending and voting on proxies, he has special powers. You have the golden shareholding and so on and so forth. But he must keep in mind that there is no immunity being a government nominee director. Though such special beneficial provisions are available for the shareholding of the Secretary Treasury or the state, the nominees directors on the board are treated equally with all other directors when the question of duties, responsibilities and liabilities are concerned. The government nominee directors of such companies therefore have no immunity from liability. The government nominee directors of such companies ought to be aware of this fact and act with responsibility, especially at a time when the state has become a visible shareholder in large corporate bodies. The other categories of state institutions include corporations created by their own statutes and public enterprises. The respective statutes set out clinically the role of the board, directors and their duties and responsibilities. Example, the Bank of Ceylon, People's Bank, NSB, there are statutes. So our articles of association is that everything is set out very clearly in them. Then I come to the other. Now these are all responsibilities and whatever. let me touch on the protection. What are the available remedies a director has when he is on a board? The provisions to protect directors. Under the provisions of the Act, a director can rely on information and advice as set out more fully in the particular section 190. A director acting on advice given by a professional on the matter in issue can fall under this category. Example, tax expert's opinion, a legal expert's opinion, a financial expert's opinion, etc. The person who can be relied upon for such advice and information are listed therein. However, such reliance is subject to the director in question acting in good faith, making proper inquiries if necessary, and has no knowledge that such reliance is unwarranted. So this is the beauty of having competent directors on your board. Now, if there is an issue of, say, anything to do with banking, say at Tokyo Cement, if I have a problem, it's why it's very easy to chair such boards with competent people, right? I have Jagan, he's the DFCC chairman on the board. So the banking, then I have Dr. Indrajit Kumar. So we don't have to go outside to get opinions. So these people have opined, that is enough. You cover yourself. But you have to ensure that is recorded. No one can later on turn around and say you have acted in a negligent manner. That is the best advice. If best advice is available on your own board, we act on that. I mean, being a lawyer, several boards I have been, Ranjit knows very well. I say the last thing is to go to courts. Utter waste of time. To recover your 50 million, you will have to spend another 30 million and wait in courts for 15 years if the matter goes up to the Supreme Court. So this is something I've made sure, unless it is really important, no way out, sometimes to satisfy your auditors, you have to go to courts. Otherwise they will say you are not. So those are the bad days. Now we have a lot of, debt collection is a big issue. Then I talk about indemnity and insurance for directors. It's another very important thing. After Justice Dr. Professor Priyani Soisa's case, a lot of medical professionals, doctors took this and they get this professional negligence insurance cover. Because it was not very common in Sri Lanka. In other countries, a doctor will never treat you if he doesn't have that cover. Indemnity and insurance for directors' actions on given circumstances may be allowed by Companies Act if the articles permit same. However, the articles of association of the company must expressly authorize same. It is, however, best if the company can have relevant and appropriate articles to that effect to obtain the best situation. The provision set out in the model articles is not adequate. D&O or directors and officers insurance policies are tailor-made and are offered by several reputed insurance companies. I would never join a board if there is no indemnity and insurance cover for the directors. Because sometimes you may act in good faith, something goes wrong. That doesn't mean that the insurance cover will protect you from, murder. No way. So you got to ensure that you have acted in good faith, all that at least you'll have the comfort of, retaining the best lawyers in town to serve you, because that will be costly. Then interim orders are permitted. Directors may obtain relief from courts in appropriate cases, circumstances. Then maintenance of this interest register. This is something most of the corporates don't take seriously. The board of directors and the directors individually must ensure that the company maintains a due and proper interest register. This forms part of the annual report for the shareholders to peruse. The particulars of entries made in the interest register during the accounting period is stated in the annual report. So now the listed companies have an additional thing, the RPTC committee, Related Party Transactions Committee, that is a mandatory thing. So I must say that overall it is the business judgment. In the Companies Act of 2007, it is very clearly seen very clearly that the duty of directors to act in good faith, the director's standard of care, the centuries-old duty of care concept of directors has been embedded in the statute expressly. That is basically the parental care to the family, similar to that. If you have that in your mind, that you will make sure that you contribute to the company the same way you look after your family. There can't be different standards. The duty, that is the best interest, acting in good faith, all that. So now I thought I will sum up by giving you a couple of tips. I call it some golden tips for directors. So some of the following are some valuable tips for any director, aspiring director, or whoever. Be mindful of accepting directorships. Do not take over past sins of others. Do not join rogue clubs. Check the history of the company before joining the board. Act in the best interests of the company at all times. Always act in good faith, where your bona fides can be established easily when in doubt. When I go for board meetings, I go to church and pray. Never act in the reckless manner whilst on the board. Never act in a grossly negligent manner whilst on the board. Always rely on your experience and knowledge in business judgment. Do not let your personal interests conflict with the interests of the company. Familiarize yourself with the important provisions of the Companies Act, which can have an impact on your actions on the board. Familiarize yourself with the provisions of the Articles of Association of the company. Note that in the Companies Act, it is specifically stated that the provisions set out therein are in addition to and not in derogation of any provisions contained in any other law relating to the duty or liability of directors or officers of a company. So if it's a listed company, you will have more responsibility. If it's a regulated company, Jagan knows we are in the insurance board. Now that the insurance regular, it gets bigger. The regulations come in. He knows being in finance companies, how it happens. Ensure that all statutory obligations of the company, example EPF, taxes, the list is long, are complied with forthwith. Compliance check either monthly or quarterly. This compliance issue has to be, because you don't know. You are relying on somebody else's data. So compliance signed off by someone, either CFO or CEO or whoever, so that you have protection. Ensure that all banks and other lending institutions are serviced accordingly. Compliance check either monthly or quarterly. Ensure that all software license fees are paid and the license are valid for all the company software. It's a new feature that has come up. The man who is not paying the license is not caught, but the board will get caught. Board wouldn't even know. Board would know how many computers are there, how many licenses are needed. So get someone to sign off. At least you can, even if you are taken to court, you say, no, my CFO has said that you has done everything. Ensure that all other statutory licenses are valid and up to date. Example, environmental licenses. There are so many licenses if you are in the regions. Sometimes the environmental license you get from the parent body in Colombo is not valid. You have to get another one from the province. If you don't have that, you will be hauled up in the magistrate. Ensure that the board is aware of the impact of certain new statutes. Example, the Consumer Authority Act, Anti-Corruption Act, Anti-Money Laundering Act, Computer Crimes Act, Data Protection Act, Electronic Transactions Act. That is why continuous training is important. That is why you find in most of these seminars, there are so many coming and following these to know. This, there was Ranjit knows the story. There was one particular very well-known chartered accountant, a gentleman who was serving for a foreign company, and outdated milk packet had gone to the market, and he was sued in Kurunegala. For 7 years that case went on. Poor man suddenly goes to the airport and can't leave the country. There is a travel ban. He didn't even know. Then only he knew that this is because all the directors were foreign, they were out. 2 local directors were caught up. They didn't even know about this kiri packet, outdated packet that has gone to the market. It happened to Tokyo Cement long years ago. A cement bag had gone to the market without the price tag because they were changing prices at a rate. So some law had defended. These are statutory offences. There is no, it's like if you go over 100, drive over 100, you have to pay the fine. These are statutory offences. One stupid law had been arguing that I didn't have the intent to do the intent, it has come out and all that. And then one day the law had not gone, the whole board was summoned to the magistrate court, Malikakanda magistrate, for not having a price tag. So you've got to be very careful if you're in the consumer market. So all these new statutes whole lot of new statutes, at least the gist of it. Understand it. These are not very big statutes. Companies Act have 534 sections, 46 forms, and 13 schedules. But these are very short ones. So, cursory glance is at least important. Regularly check whether the risk management techniques of the company are in operation. Example, enterprise risk, political risk, strategic risk. That list is getting longer by the day. Note the significance of several other important provisions of the Companies Act that deals with vis-a-vis company name, company number, special provisions applicable to private companies, solvency tests, distributions, stated capital and capital maintenance, reduction of stated capital, dividends, acquisition of shares, minority buyout right, meetings, proceedings, resolutions, major transactions, etc. These are day-to-day matters. Any director should have some amount of understanding, not a deep understanding, but at least a cursory glance of these is important. Check whether the financial reporting is done in a professional manner under the provisions of the law. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the Securities and Exchange Commission Act and the SEC rules, which can have an impact on your actions. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the listing rules of the Colombo Stock Exchange, which can have an impact on your actions. If the company is listed on the stock exchange, make sure that you are aware of the mandatory code on corporate governance and also the voluntary code on corporate governance. Even if the company is not listed, try to follow the corporate governance mechanisms in place for good governance. The norm is generally listed companies, at least 1% of your turnover must be used on CSR. So for other companies, there is no. But if you can do that, well, that is something good. We talk about that, maybe let the companies also do that. So, if consider the mechanism of CSR, corporate social responsibility for all the companies. Most of the companies in Sri Lanka do a lot of CSR projects which are very, very great. If the company is a licensed commercial bank or licensed specialized bank, make sure that you are aware of the provisions of the Banking Act which can have an impact on your actions. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the provisions of the directions made under the Banking Act which can have an impact on your actions. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the guidelines for internal controls published by the Institute of Chartered Accountants of Sri Lanka. If the company is a registered finance company, make sure that you are aware of the provisions of the Finance Companies Act and directions made under the said act which can have an impact on your actions. If the company is a registered finance leasing company, make sure that you are aware of the provisions of the Finance Leasing Act and the directions made under the said act which can have an impact on your actions. If the company is a specialized entity, make sure that you are aware of the provisions of the statute or statutes which can have an impact on your actions, in addition to the provisions of the Companies Act. Example, Bank of Ceylon. Be mindful of your actions that can be impeached by the company, directors, shareholders, creditors, and other stakeholders under the provisions of the Companies Act. Be mindful of operation and mismanagement actions and derivative actions that can be instituted by minority shareholders, impeaching actions of directors. That is thankfully bread and butter for us. If shareholders or directors don't fight, we won't have cases. If the company is a conglomerate or a group entity, ensure that you have a fair knowledge on holding companies, subsidiary companies, and associate companies and their respective roles under the company. Holding company, subsidiary company is defined in the Companies Act, but associate company is not defined, it comes from the accounting standards. So you must have some fair idea if you are working in group companies and whatever. Check whether the consolidated accounts or group accounts are done accordingly if it is a group entity. Be mindful of related party transactions of the company. Now, another amendment came in August to the Companies Act 12 of 2025, which came into operation in August, which brings in beneficial ownership. So not only related party transactions, now the company secretary and the board has additional burden to ensure that there is transparency with regard to beneficial ownership. Beneficial ownership you have in other people's names, trust and all that. So that is another feature coming in. We are having a seminar on this matter also. Use your conscience when taking decisions at board level. Make use of your own expertise when you have a superior knowledge on the subject. Never let others who are lesser knowledgeable on the subject matter in issue pressurize you to change your decisions. Always ensure that the independent directors are truly independent. Always ensure that the board recognize the views of independent directors. Do not be under any obligation to the chairman or any other member of the board. Have an independent mind of your own. Ensure that your dissent on any matter is recorded correctly at meetings. Check the board minutes and minutes of other committees where you are a party with care. Read the board minutes with absolute care before they are confirmed. There have been instances, very rare though, I have made my dissent, single dissent. Get it recorded. Okay. Sometimes when there are powerful people on boards, they might try to pressurize you. So when they say we want to buy that, 2 billion property, it's a deal, we are going to get it. And when I say, well, this is a listed company, you have to do proper due diligence, you have to do financial due diligence, you have to do legal due diligence. Instead, no, you and your due diligence, by the time you finish your due diligence, Harry will pick it up, Damika Pera will pick it up, so and so will pick it up. Right? Then you say, okay, you can go ahead with the transaction, please record my dissent. So at least at the end of the day, 10 years later, if something goes wrong, I'm hauled up in court, the judge will look at me in a different way. He might say, even so and so has said that not to go ahead with this. So that is something very important with regard to your minutes. A lot of people don't know the value of minutes. It's a contemporaneous record. You may use it 5 years later, 10 years later in a court of law. That's why the minutes are very important. Now, of course, listed companies have been asked, banks have been asked to keep your recordings also. So you not only the script, but you have the recording also. Read the minutes with absolute care before they are confirmed. See that board minutes and other minutes committees are corrected accordingly. Note that the board minutes are treated as a contemporaneous record of events and matters. If you're not an expert on the matter in issue, ensure that you rely on third-party expertise on the matter, either at board level or externally. Keep records of same. That is very important for a rainy day. Use of information and advice of third parties is permitted under Section 190 of the Companies Act with clarity. Any individual on the board can rely on the third-party expertise in given circumstances. Always remember to keep such evidence on record to be used as evidence when needed later. Legal opinions, emails, whatever. Be aware of the provisions of the Companies Act and other relevant statutes which attract personal liability, including criminal liability, which again is personal in nature. Make use of the directors and officers' insurance cover. Ensure that a proper interest register is maintained by the company and all relevant interests of directors, including yours, are duly entered in the said register. Make use of a particular section 526 of the Companies Act, power of court to grant relief in certain cases when needed to obtain appropriate relief from court. Make note of actions that attract personal liability, civil and criminal both, as set out in any other statute or statutes that impact on the company. Ensure that all your actions are carried out in a professional manner, reasonably with dignity and honesty. Independent non-executive directors are invited to boards mainly due to their expertise. Expert in finance, expert in law, expert in marketing. Ensure that such expertise is made use of by the board and not ignored. If you feel uncomfortable on the board, exit forthwith. Independent directors should resign no sooner they feel their independence is eroded. Do not accept board appointments if you cannot dedicate sufficient time for the board matters. Do not accept too many directorships if you cannot dedicate sufficient time for each directorship. Be aware of your rights as a director under the Companies Act, the fact that you are privy to board minutes, etc. Check whether the CEO, Chief Executive Officer, is performing his obligations correctly. Check whether the subcommittees on the board, example, the Audit Committee, Remuneration Committee, Nomination Committee, Related Party Transactions Committee, etc., are in operation in the correct manner. There are so many other committees we have in banks also. Check whether the company external auditor is performing his rights professionally. Check whether the company secretary is performing his rights professionally. Ensure that the internal audit mechanisms of the company are in order. Be familiar with Sri Lanka accounting standards that may have an impact on your company. Also note that Sri Lanka follows IFRS, International Financial Reporting Standards. Be familiar with ESG regulation that may have an impact on your company, environment, social, and governance. Now that is becoming mandatory. Now it started this year. So it's additional burden for the directors to know that, and you're following it, and now they are going to measure it also. It's another new area that is coming in. Avoid being a mere passenger on the board, endorsing all decisions of the board in a passive manner. Be cautious when giving personal guarantees for corporate benefit. Remember that ignorance of law is no excuse. However senior you are as a director, believe in continuous training, as the role of directors is a tree with a fast growth. Very important to continue training. Remember that accepting a directorship is not joining a cocktail circuit. Never discuss boardroom matters with family members. Never discuss boardroom matters with friends or associates. Do not disseminate price-sensitive corporate information to any third party who is not entitled to know them. Do not trade your principles for money. Nay, an Enron in the US, or a Satyam in India, or a Golden Key in Sri Lanka. Thank you very much.
He still remains a giant. He had the ability to express in simple language and in a few diagrams any complicated theory or an idea. He was a master at conceptualizing and expressing effectively with excellent verbal and presentation skills. Today, for the fourth Professor Uditha Liyanage Memorial Oration, we had another exceptional personality in the form of Dr. Harsha Cabral, President's Counsel, who is a colossus in the field of law, particularly in corporate and commercial law, and a person with years of experience as chairman and director of several key institutions, including banks. Together with your knowledge, tremendous knowledge and experience, the most striking feature to me, Dr. Harsha, is your simplicity, a virtue worthy of emulation. We are privileged to have had you as our orator today. Dealing with your topic for this oration, you made it clear that the title director is not a mere status symbol. It is packed with great responsibility to ensure organizational growth. In that light, you gave a series of practical tips, and some that stuck in my mind are: always act in good faith, have an independent mind of your own, there are personal liabilities, don't be a passenger on board, and here's the gem, you cannot have a 5-star life with a 3-star income. A very big and a sincere thank you to you, Dr. Harsha, for the enlightening oration. Also, I wish to thank the Oration Guidance Committee, the Oration Operations Committee, and all those who assisted us in so many ways. And to the Director of the PIM, Dr. Asanka Ranasinghe, for his cooperation. And finally, to all you ladies and gentlemen who attended this event, we are honored by your presence. May Professor Uditha Liyanage have a short journey in samsara and receive divine blessings. Good night.
Thank you very much, Mr. Dehan Senivara. And with that, we conclude the fourth Biennial Professor Uditha Liyanage Memorial Oration. The oration delivered by Dr. Harsha Cabral will be published in the next issue of the Professional Manager magazine, as well as in the Slim magazine. And it will also be available on the websites of PIM, CIM, and Slim. And ladies and gentlemen, I wish you a safe and healthy future. Good night. Thank you.